If you owe money from a company and that company goes into liquidation and the shareholders appointed that liquidator, does the choice of liquidator matter to creditors? I want to give my perspective, and I want to tell a story about a group of clients that we helped in this very situation. It involved a construction company. Shareholders appointed their own liquidators, and those liquidators formed a very quick view that the company had been traded appropriately. There was no overdrawn current accounts that could be pursued against the shareholders, and ultimately they were just going to sell some assets, and there would have been 1 cent maybe in a dollar to the creditors. The total pool of creditors was about $7 million. These are subcontractors, these are small business owners who, as salt of the earth, had done all of this work and not been paid. I acted for a group of these creditors and formed the view that the directors of the company had breached their duties or were likely to have breached their duties, and we wanted this to be properly investigated. We wanted liquidators appointed who had a reputation of pursuing directors for breaches of duties and were litigious. So we ran a campaign to replace the liquidators. We got creditors' support to replace the liquidators. And in these situations, if the majority of creditors in number and value vote to replace the liquidators at that initial stage, that liquidator can be replaced. We got our liquidator appointed, who then investigated all the areas that we considered were necessary and formed a very different view than the shareholder appointed liquidators. What ultimately happened was freezing orders were obtained against all the directors' properties and proceedings were commenced to recover claims by the creditors. Can't say the numbers because it's confidential, but what the liquidators were able to achieve is a 7-figure settlement with the board of directors of this company to resolve what we now know was very clear breaches of duties. It emphasizes, in my view, the importance of having the right liquidator for the job. There are some liquidators who are not very aggressive, and maybe that's what's needed in that particular case. But often I find creditors are looking for someone to investigate, to pursue claims, and to probably pursue it at the liquidator's own cost, because at this point, the creditors are not willing to put any more money into the company, which is fair enough. So in my view, the choice of liquidator matters. It's something that creditors should consider at the outset of the liquidation and work together. What I find is creditors are generally scrambled and they kind of go on their own paths, but this is a time to unite and to put in one person that you all believe will get the best outcome for you. So if you're a creditor in a liquidation and you're wondering what is the right decision, who should be appointed, we offer a free initial consult where we can talk to the issues and the strategy and tailor that for the creditors. You can book that at norlinglaw.co.nz.